Ready? Let's start. In this revisional application, the petitioner has assailed the order dated 07/06/2018 passed by the Chief Judicial Magistrate MALDA in case number 955C/17, thereby disposing of the petitioner's application filed under section 156 within bracket 3 of the Code of Criminal Procedure. The brief facts leading to the instant case is that the petitioner is an account holder with the State Bank of India Kaliachak branch and is having a savings account bearing account number 17982693584 on 08/07/2017 at about 4:20 p.m. The petitioner, with the intention to withdraw money from his account, visited the nearest automated teller machine within bracket ATM at the Kaliachak branch of the respondent bank by inserted his ATM card in the machine to withdraw the cash of rupees 30,000, but unfortunately the petitioner was unaware of the fact that the said machine was out of order, and so the transaction became unsuccessful and the petitioner could not withdraw the said cash. Guard attending to the ATM kiosk told the petitioner that the said machine did not have cash and the petitioner was asked to withdraw cash from the adjacent ATM. Accordingly, the petitioner once again inserted his ATM card in an adjacent ATM machine and withdrew a sum of rupees 10,000. But to his shocking dismay, the petitioner, after seeing the receipt, came to learn that an amount to the tune of rupees 40,000 was deducted from the petitioner's account, which included the sum of rupees 30,000 due to malfunctioning of the machine. Thereafter, the issue was brought to the notice of the bank, but the bank was not taking up his issue with seriously. So the petitioner, without further ado, on 17/07/2017 wrote a letter to the opposite party number 2 bringing to his notice regarding the irregular deduction of cash from the petitioner's account. The opposite party number 2 did not pay heed to the said letter, so the petitioner lodged a complaint with Vaishnavnagar Police Station, which complaint was diarized as GD entry number 1012/17 dated 18/7/2017, seeing the lackadaisical approach of the police authorities is not acting upon the petitioner's complaint. A representation was made to Superintendent of Police MALDA requesting him to take appropriate action by directing his subordinates on 25/09/2017, but of no effect on 13/09/2017. The petitioner sent a notice to the opposite party number 2 requesting for his assistance in resolving the petitioner's grievance, since the petitioner had incurred monetary loss for no wrong of his, but shockingly, instead of helping the petitioner and alleging that the petitioner had distorted the facts for his wrongful pecuniary gain. It appears that the petitioner had informed the branch manager, Brokant branch PO, Bhagwanpur district, Malda, by his letter dated 17/07/2017 after waiting for a period of 9 days from the date of alleged incident. The petitioner's grievance was redressed through online customer service department of State Bank of India, showing the transaction as successful thorough inquiry, but it was rejected by the customer service department through online with advice that the transaction was found to be successful as it is depicted from the Annexure B to the affidavit in opposition. on the petition under section 156 within bracket 3 of the Code of Criminal Procedure before the Chief Judicial Magistrate MALDA. After lapse of 2.5 months, the learned magistrate had ordered preliminary inquiry, and on the basis of the inquiry report of the sub-inspector of the concerned police station was pleased to drop the case para. It is pertinent to note that the statement of the bank official during investigation as depicted police report is on general issue that in the event if any transaction fails due to mechanical or other failures, the deducted cash has to be credited by the bank authority after receiving complaint from the ATM card holder. The record reveals that transaction of for rupees 30,000 and rupees 10,000 was completed successfully by the petitioner, and cash was deducted from the account of the petitioner as per the ATM customer advice slip. The details of the transaction from the record was also investigated by the police, and it was clearly seen that the transaction of the said amount were made by the account holder of account number 18592093486 successfully from the ATM of SBI Kaliachok branch on 08/07/2017 para. In a reply to the contention so made on behalf of the opposite party number 2, the petitioner contended that there has been typographical error in the account number in the main revisional application, which does not form the basis of the present case. The EJ log as well as no excess cash certificate are documents in custody of the opposite party number 2 being the manager of the issuing branch, making the same unworthy of reliance because the opposite party number 2 during investigation has failed to provide to the police with the CCTV footage, and as the fact is sheer negligence on the part of the opposite party number 2, because despite the receipt the complaint of the petitioner opposite party number 2 as 17/7/2017 failed to preserve the CCTV footage and subsequently has taken the ridiculous defense that the same cannot be restored beyond a period of 90 days para. I do agree with the contention as advanced by the rival parties, but the question remains in the judicial mind as to why the claim was not entertained properly para. I found on bare reading of the complaint details and economics journal annexure A, it does appear that the response of the code 000 means successful transaction, and it does not show mechanical fault in the ATM machine, so the CCTV footage is required to be viewed by proper investigation into the matter as to whether at all it was the petitioner who withdrew the entire money by operation of the ATM machine through his ATM card or anybody else para. I am of the considered view in the context of the finding above that when the electronics journal speaks of successful transaction and yet a complaint is registered, it is imperative for the bank authority to hold through inquiry into the dispute on their own by obtaining the CCTV footage, and if not available beyond the period of 90 days, it is desired on the part of the branch manager or the concerned authority of the bank to have preserved the CCTV footage on receipt of the complaint on 17th July 2017. As on the date, CCTV footage was supposed to be preserved in the system that apart even today, if such footage can be retrieved through the motherboard of the computer system which is maintained by agency appointed by the State Bank of India. Stop. Thank you.